Hello friends, Namaskaram. Myself is Dr. Soni. I am an advocate and a corporate lawyer. In today's class, we will discuss about Section 19 of Prevention of Corruption Act that mandates a valid sanction order to prosecute a public servant under Section 7 or 11 or 13 or 15 of PC Act. Without a valid sanction order, the proceedings would be nothing but abuse of process. Now, the important point arises: what factors are required to be considered while according a valid sanction? For this, we have to understand the theoretical perspective. Please be noted, the basis of sanction order is to provide effective protection to honest public servant to ensure they can perform their duties without any fear of undue or unwarranted litigation. But in practical scenario, it is observed that the sanction order is inter alia executed by the concerned sanction authority in the routine way without considering the rights of the concerned accused. Please be noted, the protection of section 19 of PC8 is applicable at the stage of trial or cognizance. It is not applicable at the stage of inquiry or investigation. For this, we have to emphasize on section 17A of PC8. And apart from that, the authority according the sanction must be competent to remove the public servant from its office. For example, if the sanction is accorded by the appointing authority who is not competent to remove the public servant from its charge or position or office, in that scenario, section 19 of the PC Act would be affected and the proceedings could be challenged on that point. Now, the important point arises when to challenge the validity of sanction. Sometimes it is seen that you might file a proceeding to quash the sanction order, but the approach of yourself might be in the anxiety because we have to follow the track which is inter alia sustained by Honorable Supreme Court so that we could challenge the proceeding in effective way and could have results. For this, we are required to note down two important points. Number one, the sanction authority is not bound to accord sanction. If sanction is refused, in that scenario, on same material, a new sanction cannot be accorded. On that point, we are having judgment of Honorable Bombay High Court, that is Dada Sahib versus State of Maharashtra. Judgment date is 27th of November 2024. We have to note down that is point number 2. The sanction authority is duty bound to give reason while according sanction. If there is no reason, in that scenario, the proceeding concerned with sanction would be illegal or would be abuse of process. Judgment is Inderjit versus Santosh. Judgment date is 19th of April 2022 and it is pronounced by Honorable Supreme Court of India. Please be noted. Now I am coming on the important point, that is importance of giving the representation. To understand that point more effectively, we have to consider the important judgment of Honorable Supreme Court. That is State of Madhya Pradesh versus Dr. Krishna. Citation is 1996, Volume 11, SCC, page 439. The key point is that the concerned authority is totally bound to do the complete scrutiny of the record. Apart from that, it may consider all the material that may tilt the balance in favor of accused. So, sanction authority is duty bound to consider all the objections of the accused. Although there might be a conflict on that point, some authority says the authority is not bound to hear the accused, but the position is differ because the authority could consider the scenarios that may tilt balance in favor of accused. Apart from that, we have to study section 511 subclause 2 of BNSS that says the objection regarding the sanction must be taken at earliest. If the objections are not taken, in that scenario, if any perjury is caused, then you could not be compensated. So you have to raise all your point so that you could rebut the presumption and could inter alia convince the authority to refuse the sanction. Apart from that, regarding duties of sanction authority, we have to follow the important judgment of Honorable Supreme Court, that is CBI versus Ashok Kumar Agarwal. In that judgment, certain guidelines are propounded. Number A, the prosecution agency must submit the entire material to the sanction authority, including number 1, the FIR, number 2, disclosure statements, number 3, statement of the witnesses, number 4, recovery memos, number 5, draft charge sheet. Basically, it is the prospective charge sheet to be submitted. Please be noted, the draft sanction is not required to be submitted. If it is submitted in that scenario, the sanction would be cyclostyle. In that regard, judgment of Honorable Bombay High Court, case title is Anand versus State of Maharashtra, is quite important. In addition to this, the agency is also required to send the document that may tilt the balance in favor of accused. So we could say that the authority could consider the scenarios or the circumstances that may tilt balance in favor of accused, so that if on the basis of material on record no case is made out, the authority could refuse to incline sanction. Number B, the authority has to do complete scrutiny of the whole record. For this, the authority has to follow the two important principles. Number 2, to apply its mind in the independent way. Number B, to take into consideration all the material relevant to decide whether to grant sanction or to withhold the sanction. Number 3, the power of sanction is to be exercised strictly, keeping in mind number 1, the public interest, number 2, the protections available to accused under law. Number D, the order of sanction should make it evident that the authority inter alia considered all the relevant material, and apart from that, it was aware with all the material. Number E, in every individual case, the prosecution has to establish and satisfy the court by leading evidence that the entire relevant facts has been placed before the sanction authority and the authority has applied its mind on the same and the sanction had been granted in accordance with law. So basically, whenever we are going to study the sanction order, we have to keep in our mind the said principle so that we could understand about the validity of sanction order accorded in our case. If the concerned sanction authority failed to consider all the said perspectives in that scenario, sanction order would be nothing but abuse of process and we could sustain our objection at the stage of trial. But please be noted, in the specific case where sanction is refused earlier and it is issued again on same material, there is no need to wait for trial. And apart from that, the protocol of section 19 subclause 4 of PC8 would not be applicable and we may challenge the proceeding directly. And apart from that, if it is accorded by the authority who is not competent, or apparently it is going to indicate that the sanction is cyclostyle or based on non-application of mind or specific reasons are not given, in that scenario we may sustain our objection even at the stage of discharge argument. So I think that I am totally able to enlighten all of you about the subject. If you are having any query, please feel free to submit your points in the comment box so that I could answer them as per my little knowledge. See you in the next video and chapter. Till then, Jai Hind, Jai Bharat.